A legal bid to stop the JSC investigating retired judges has been dismissed. Now, NPO Open Secrets says it will fight any appeals to that ruling. The application was brought by retired judges Willie Seriti and Hendrik Musi. The dismissal paves the way for the JSC to probe allegations of gross misconduct against the two. It's related to their handling of the Arms Deal Commission of Inquiry. Let's speak to Luthando Vilakazi from Open Secrets. Ms. Vilakazi, good morning and thank you very much for your time. Firstly, your reaction to that judgment as the fourth respondent in that particular application.
Thank you so much, Luthando, for having me. So obviously we were very pleased with the judgment being dismissed, and we were somewhat expectant of that outcome only because when you look at the arguments that Judges Seriti and Musi made in their papers, it was somewhat clear that the notion that retired judges who have been discharged from active service somehow being under the purview of the JSC Act being unconstitutional is plainly wrong on the face of the legislation, and that is what we found the court to agree with.
One would say it was an important judgment because it clarified that particular aspect where others might have thought, why pursue judges well into retirement? And Judge Sutherland took his time to explain that particular phrase that you've said, that when one is discharged from active service, it's not similar to somebody who is considered to have retired from office, that even though you are not performing a judicial function, you never cease to be a judge.
Absolutely. One of the notions that Judge Sutherland kind of expanded on was the idea of being a judge for life. Judges Seriti and Musi argued that it is not fair to assume that you maintain those duties even post your active duties as a judge and once you've stepped down from office. And I think the reason why Judge Sutherland, at least in the judgment, laid that out is because you continue to benefit from so many aspects of legislation as a judge who has been discharged from active service, least of which is pensions that are paid out from the public purse based off of the number of years that one was active as a judge. And, you know, there's a number of other regulatory aspects to the legislation that retired judges continue to enjoy and be a part of. And therefore, it only follows that any other aspects, including disciplinary processes, should also be applicable to judges in that position.
Now, you, along with Shadow World Investigations, actually brought us to this moment by reporting the paper to the JSC. Talk to us about the decision to take this matter to the Judicial Service Commission, because honestly, you could have just done what many NPOs have opted to do, which was to go onto platforms and call that commission report what it was, a whitewash. But they took it no further, but you opted to go this route of reporting them.
Yes, absolutely. So that strategy, together with Shadow World, as you've said, it's about making sure that, our organization is centered around accountability for economic crimes that have human rights consequences. The arms deal falls squarely within that category of human rights abuses and economic profiteering. And even though, Corruption Watch and Right to Know did take the Commission's report itself on review, and the report was set aside, on the basis that the investigation during the course of the inquiry was not conducted in a manner that was sufficient, essentially. But that means that someone failed to act in a way that would ensure the investigation was conducted properly. And I think it's important to not have, sort of dealings of corruption be faceless. There are people behind these injustices, and there are people behind cover-ups, whitewashes, and we should not be afraid to seek accountability and to call them by name and ask them to account for their failings.
There have been those that have said that if the judges are going to be taken to task on their conduct in that particular commission, what of the evidence leaders? Because that particular judgment from 2019 also touched on the evidence leaders, that there were instances where they could have posed very probing questions to some of those that had come to testify, the likes of Fana Hlongwane, but they felt, and Chippy Sheikh, and they felt that, no, it wasn't done. It was as though you just take somebody's version and let it be so. So in that instance, do you believe that it was only the judges, or it should only be the judges that are taken to to task on that particular matter?
I think it's something that we would need to consider further. On the one hand, it's important to make sure that the people who were actually in charge of the commission are able to account. And the reason why they would need to do so is because it would be their responsibility to ensure that, if an investigation is not being led in a proper manner or is being led improperly, they should be the ones to question, why are you not probing this point? Why are you not pursuing this line of questioning? And ultimately, they are not the only ones who are responsible for the complete failure of the commission. But I do think it's important because of their office as, officers of the judiciary and having to uphold the Constitution as impartial and fair actors within government. It is most important that we see accountability start here.
Mm-hmm. No, it's honestly a first, what we're about to witness now, where the conduct of judges who sat through a commission and ran it are going to be put before the JSC on their conduct. Very, very important, because we've had many commissions of inquiry, and possibly there could be NPOs that decide to challenge even the conduct of those judges. But before this gets underway, there's a possibility that the pair of judges could appeal. Are you prepared for any further legal action?
So they have until the 9th of May to lodge a notice of leave to appeal to the court. If that were the case, we would be prepared to contest that. And the only reason why is, this whole process has been going on for, almost excess of 10 years. And we do not want a situation where persons who are privileged enough to employ the most expensive legal counsel and attorneys out-litigate NPOs and NGOs such as ourselves and try to exhaust us through court processes. And we don't believe that that's what our courts are set up for. And in that case, we would absolutely contest an appeal.